here and talk to you here in Dublin on faith-based arbitration. I was asked to talk about arbitrations in the Beth Din, but I thought it would be more useful and forward-looking to talk about faith-based arbitration because it is a certain hot topic over our side of the Irish Sea, and it might well be or become here. Now, some of you may remember that on the 7th of February 2008, Archbishop Rowan Williams, the Archbishop of Canterbury and head of the Anglican Communion worldwide, gave a speech at the Royal Courts of Justice in London, in which he appeared to suggest that English law would have to accommodate the application of Muslim Sharia law within communities of Muslims living in England. His remarks unleashed a storm of protest. The tabloid press in particular stirred up visions of bearded judges imposing medieval punishments on hapless British citizens, like cutting off their hands, and of foreign and alien systems to our law supplanting our legal system and replacing it with a parallel code that would be imposed on Muslims and perhaps even non-Muslims. Unfortunately, the Archbishop of Canterbury spoke in opaque terms and led to enormous controversy about what he meant, which the Church of England has had to try and explain ever since. In fact, the Archbishop was completely right in some respects, and he was equally wrong in others, depending perhaps on how you interpret his words. He was right in that English law, and I assume the law here, already accommodates the principle of arbitration, which in essence, two people agree to submit their dispute to be resolved by a third person. The arbitrator is entitled, with the agreement of the parties, to decide the dispute in accordance with whatever legal system or principles they choose. The system can be the law of the country where the arbitration takes place, or equally it could be the law of another country, or the different system of law entirely, such as the law of a system of religious faith. I assume that Archbishop Rowan probably knew that arbitration based on faith principles has been part of the law of England and Wales for a long time. None longer, in fact, than the court of law known as the Beth Din. Literally in Hebrew, a house or place of law or justice. The law court, in other words. And in order to see how the Jewish religion evolved this principle, I'm going to make a very brief journey into history. Now, as you may know, the source of Jewish history is the Bible. It's not just the source of Jewish history, it's the source of Jewish laws. And the Bible, by which I refer to what in Christian countries is called the Old Testament, is not only a legal system, but is also a way of life. And sometimes it's a little bit hard, actually, to tease out what's the law and what's the way of life. Judaism has gone its own way, and Christianity has to some extent gone a different way, although the basic principles are the same, which is why we often talk about the Judeo-Christian system of law. In the Bible, you will find laws about tortious injuries to others, helping the poor, the widow, and the orphan. You'll find out about family law, obligations to one's spouse, laws of business and commerce, laws about war, protecting the environment, employment, kindness to animals. These are just a few examples. in their time, the laws were revolutionary, depending on how far the Bible goes back, but at any rate, we understand it to go back in Jewish law. In Jewish tradition, it goes back more than 5,000 years since the Torah was given by God to Moses on Mount Sinai. On any basis, it is a system of law thousands of years old, at least 4,000 years. So it was highly revolutionary in its time. But it went further than that, because if you know your Bible, you will remember that after Moses successfully, with the help of a little bit of help from God, led the people of Israel out of Egypt, and they received the law, the Ten Commandments, on Mount Sinai, and in Jewish tradition, Moses was up there for 40 days, which might seem a long time, but it's not very long, because he wasn't just given the stone tablets of the Ten Commandments, but in Jewish tradition, God dictated to him somehow the whole of the Old Testament. It's a bit problematic. Did he dictate him the day he was going to die and all that? But Jewish tradition accommodates all that. And not only that, but he also made known to Moses in a process of divine inspiration the commentary around the law. That was an oral law for many, many hundreds of years until, under pressure from Jewish dispersion out of Israel into other countries, it came to be redacted and written down into commentaries, which we now call the Talmud. Now, you may remember that Moses, being the sole repository, all the people came to him to have their disputes resolved. And he would sit there, and there would be queues of people. And you remember the episode in the Bible when his father-in-law, Jethro, comes from Midian, and he says to Moses, "This is not good. You will be worn out. What you now have to do is create a system of judges. Judges of tens, judges of hundreds, judges of thousands. In other words, a local court, a high court, a court of appeal, and a Supreme Court. And that is a biblical invention." So in biblical Israel, there was a system of local and higher courts. The Supreme Court was called the Sanhedrin, and it had 70 judges. And on many decisions, in particular capital punishment, they had to be unanimous, which was why, in our tradition, capital punishment virtually never, ever occurred. In fact, just out of interest, the Parliament in Israel today has 70 members, an echo of the biblical Sanhedrin. When Jewish people ultimately settled outside Israel, either by choice or under compulsion, they naturally sought to resolve their own disputes under the system they were most familiar with. And occasionally they were allowed to do so, and very often they were not. For example, in southern India, in Kerala, there was actually so much Jewish autonomy that the local rulers were entirely willing to let very ancient Jewish communities who had traded with South India since the days of King Solomon and the First Temple, their own autonomy, and the copper plates which legislated for it are still there to be seen in Cochin, if anyone has been there. Very, very interesting to see. So evolved the system of courts known as the beth din. There would have been a beth din, or in the plural, bate din, across Europe in Roman times, because the Romans occupied and destroyed Jerusalem and the temple, and forcibly depopulated and shipped out all the Jews to the Roman Empire. And that is probably how Jews came, at least in numbers, to Europe, including, I think, as far as this country, certainly in England and Wales. And they would have had, probably informally, and well out of the eyes of the authorities, one imagines, a beth din in important centres of Jewish population, such as Lincoln, in medieval times. In 1290, the Jews were expelled from England. And those expulsions were, unfortunately, a fate of Jews across medieval Europe. They were expelled from Spain, from Portugal in 1492, and from Germany in the 12 or 1300s. In 1665, Jewish people were allowed by Oliver Cromwell to come back to England. And we don't know when, but it's a reasonable supposition that certainly by the 1700s there would have been informally a Jewish beth din that would have been operating in England. So you've got a very early example of a Jewish arbitration tribunal and an even earlier example of a Jewish arbitration tribunal recognised by the national courts, because certainly by the 19th century, when arbitration became a feature of our law, the Jewish religious courts were a recognised arbitration tribunal, even though arbitration law at that time was very fledgling. If you fast forward to today, it is in fact not only Jews who have their own religious tribunals, but there are latterly Muslim ones as well, and there's a very competent Muslim arbitration tribunal based in Leicester, which is finding its feet. Now, I don't know very much about Muslim arbitration, although I occasionally talk to the judges of the Muslim Arbitration Tribunal, but I do know a little bit about the Jewish version, so I'll tell you a little bit more about that. A beth din comprises of 3 judges. They are usually, if not invariably, clergymen, rabbis, but they're not ordinary rabbis. They have to have a special extra qualification which is in Jewish law. Your average rabbi, if I can put it like that, could probably resolve questions of his parishioners on various things, but if there was a legal dispute, he'd have to know a lot more. Obviously, whereas lawyers, we're familiar with the fact that law is highly complicated and technical, and indeed very few people would know all the law from criminals to civil law, but they would specialise. So it is with Jewish lawyers. And a Jewish law judge is known as a dayan, plural dayanim. We have several bate din in England. The most well known is called the London beth din, also known as the Court of the Chief Rabbi, although in fact the Chief Rabbi doesn't sit in it because he's not a dayan. The reason it's the most well known is that approximately 60% of British Jews, it used to be higher, are affiliated by membership to the centrist Orthodox groupings under the Chief Rabbi, and that court, therefore, is the court of the largest group of Jewish people in England. But there are smaller denominations who have their own beth din. It is also possible, if the people wanted it, to set up, you could constitute your own beth din, much like you could constitute your own arbitration. In fact, in Jewish law, we already had, many years ago, the system whereby the claimant can choose one judge, the defendant can choose a second judge, and the 2 judges then choose the 3rd judge, something quite well known in arbitration, something that has always been there in Jewish law. Now, as a matter of Jewish law, it is not permitted to take a dispute between Jewish people to the secular courts. The principle of Jewish law. And the reasons are not hard to discern. Number one, that communities generally don't want to air their dirty linen in public. But it's embarrassing to have a dispute between 2 people, perhaps religious people, members of the same faith, and they don't want to go outside. The second principle is a Jewish principle known as desecration of God's name. Something that would create a feeling in the outside world, something bad about a Jewish person, and people would say, not just something unpleasant about Jews, but something unpleasant about the Almighty, is considered a very serious religious infraction, and you don't want to do anything to risk that. And it may just be also a feeling that people would prefer to keep the resolution of their dispute private and informal. In other words, all the usual reasons for going to arbitration. In England and countries with similar legal principles, like the United States and Canada, when parties go to a beth din, they sign a submission to arbitration. And the reason for that is the reason I think you have here as well. Arbitration has now advanced into a sophisticated legal system of its own, and it parallels the courts, but it's quicker and cheaper and more informal. But of course, critically, when you sign a submission to arbitration, you are signing a legally binding contract to submit the dispute and to abide by its outcome. And if you have agreed to do that, then of course the routes for appealing are extremely narrow, and deliberately so that arbitration doesn't just become an instrument of oppression in litigation and just another tier in which you can have as many bites of the cherry as you want. That would be against the very reason people want to arbitrate in the first place. So when you submit to arbitration, you submit to the decision, and the decision can be enforced by the courts. And in the Arbitration Act in England, and I dare say here, they actually specify, although they don't need to because it would be implied, they specify that the parties can choose any system of law with the arbitrator. So if two people want to go and have their dispute heard in accordance with the law of Afghanistan, I don't know why you would, but they can, and they can certainly have it decided by a system of ecclesiastical law, Roman Catholic law, or Jewish law. The proceedings before a beth din are exactly as you'd expect them to be. The parties present their case in turn, the tribunal hears witnesses, and hears submissions. Generally speaking, there are no advocates in the beth din. I've done a few beth din cases in my time, and I'm always extremely nervous about doing them because I'm an English lawyer. I'm not a Jewish lawyer. Jewish law, there's a Jewish Law Association, and its publications would probably fill a bookshelf this wall. Jewish law is a very ancient, highly sophisticated system of law, with principles that in fact are mirrored in many modern systems of law. It was a necessity in a fairly refined, sophisticated Jewish way of life in biblical Israel and outside, that you needed to have laws about commerce, for example. And of course, if you think about it, the laws that we have today about commerce and property, even going back to things like very basic concepts like bona fide purchase of the value without notice, any civilized legal system has to involve doctrines like this. And I'm often amazed by the close parallels between the system of law with which I'm most familiar, which is England and Wales, and Jewish law. And as you know, Jewish students sometimes go to a yeshiva, a Talmudical institute, where they are essentially law students. That's what it is. It's a university law degree. I mean, it might have the veneer of a religious, and that's because Jewish law is so inextricably tied up with the Jewish way of life, but essentially they are Jewish lawyers, which perhaps is why we have so many Jewish lawyers. At any rate, my side of the water, the Jewish community here, having once been very substantial and being less substantial now. In fact, you probably know that the Jewish community in Ireland is a highly distinguished one, going back many, many years. One of the chief rabbis of Israel came from Belfast, and his son, Isaac Herzog, is the leader of the opposition. Israel has just lost the general election.
Grandson.
Grandson, thank you. Talking about elections. Sorry? Yes, father was president. Talking about elections, I'll probably lose the one on May the 17th, so don't get too excited. Maybe that will give me back my life and I'll be able to get back to work a bit more often. I won't mind about that. Also, there have been at least, I think, 2 chief rabbis of Ireland, Rabbi Jacomovitz and Rabbi Mervis, who've gone on to become chief rabbis of Britain and the Commonwealth, Rabbi Mervis being the present one. He is a rabbi here in Dublin. Jewish law principles are not exactly the same as English law principles. Amongst the differences I would mention are that Jewish law never has had a concept of bankruptcy. Basically, if you have an obligation in Jewish law, you cannot go bankrupt to avoid paying those debts. The debts stay with you. Similarly, there isn't a principle of limitation, generally speaking. Of course, companies were a Victorian invention, so you won't find any reference to companies or separate legal personalities to the individuals in the Bible, so they're not in Jewish law either. But a beth din, when faced with corporate matters, will usually adopt them and apply them because they recognise they're part of the society in which the disputants actually live. A more well-known part of Jewish law is the prohibition of charging interest, because it comes from the Bible. In biblical terms, if someone comes to you for help, it is forbidden to charge them interest. Now, in a commercial context, that's outside the rule of the Bible, but many very religious Jews prefer not to charge interest in a commercial context, just in case they might be guilty of an infraction of Jewish law. But they get around it, much as Muslims do, by having a profit share or some other arrangement like that. We lawyers are marvellous at fictions, are we not? And we can normally find a way out of just about anything, and we lawyers are great at making black come out as white. Well, Jewish lawyers do that too. Another feature of Jewish law, which doesn't resonate so well in current day society, and which the beth din often therefore struggles with, is that the sons, particularly the eldest son, inherits in priority to daughters. That came from the Jewish conception of society, which was that the provider was the man, and the wife would come with a gift dowry from her family, and her responsibility was the home and the children. And consequently, a wife would join her husband's family, and she would be obligated, the husband would be obligated to maintain her. So there was a perfectly good social reason for preferring the sons to the daughters. But of course it doesn't resonate terribly well today. And having been in a few beth din disputes myself, it's difficult. On the one hand, the religious judges understand very well, they're quite sophisticated people. One or two of them are actually practicing lawyers. And they're not very happy with the preference of sons to daughters, but there's a clash between their religious instincts and their modern day social instincts, and they have to decide it as best they can. But there's one really important principle in Jewish law which helps them through, and that is the principle known in Hebrew as Dina Malchus Dina. The law of the country is the law. So the beth din has a wonderful get-out. If it doesn't know how to deal with a company, it can apply that principle. But it doesn't have to apply that principle in every single case. So when it comes to sons and daughters, it often finds a way of saying, well, we don't have to apply that principle here. They can pick and choose. So they can apply an amalgam of Jewish law, and where Jewish law doesn't quite meet the case, they can apply the local law or any system which they wish. Which means that when you're advising a client going to the beth din, it is somewhat difficult. I mean, it's pretty difficult for us, isn't it? When you know, even knowing that you're going to go to the Supreme Court and you have Justice Mary Coffey, you know probably what she's likely to think, but you can never be certain. And one principle of, no disrespect to you, Judge Ramon, well, we all know when we're litigators, we've all been in cases we expected to win and we lost, and cases we expected to lose and we won. So it's not that much different in the beth din either. Now the London beth din deals mainly in property, employment, partnership, joint ventures, and inheritance. And their awards are routinely enforced in court if they're not obeyed. I'm glad to say that they're almost always obeyed, but of course occasionally a party is dissatisfied and seeks not to comply with the award and then they have to be taken to court, and that's never, a very happy outcome. A couple of cases just to illustrate it. There was a case in the High Court in December 2010 called Schwebel and Schwebel, where sadly between two brothers arguing about their father's property, and the dissatisfied brother went to the court of law, and the Queen's Bench judge said this in paragraph 14 of his judgment. He referred to the Arbitration Act defining a question of law, meaning law of England and Wales, and the relevance of that is that you can take a point of law to the court by way of an appeal from a tribunal, but it's a point of English law. And so, he says, it follows that this court cannot entertain an appeal under the Arbitration Act on a question of law, where the law being applied by the arbitrator is a law other than the law of England and Wales. There is a good policy reason why the English courts will not entertain appeals in relation to foreign law. That is because the English courts dispense English law and could only rule on foreign laws on the basis of evidence advanced before the court. I leave over the question of what a court would do if the parties had agreed expressly that there could be a right of appeal to the English courts on the question of foreign law. That was not the case there, and it's not usually the case. So, of course everyone knows that. If you go to the beth din, don't expect to go on to the English court and complain that they didn't follow English law. They don't have to follow English law. That's why you go there. Another perennial problem which we struggle with in our system is illegality. And indeed, I'm told, I haven't read it yet, but a crucial decision of the Supreme Court came out just yesterday on Lawtel, which has changed the law yet again on illegality. And there was a case also between members of the family called Soleimani and Soleimani before the beth din, which ultimately went to the courts in 1998. An unusual case involving Jews of Persian origin who were buying and selling carpets from Iran, but in a way which infringed the criminal law of Iran because it evaded Iranian tax. And the beth din reached a decision, and that one was successfully appealed because the court found that if they enforced the award of the beth din, it would involve infringing the criminal law of Iran, so it's against public policy. So if you're trying to evade the law of even a country like Iran, not necessarily a friendly foreign country, you might well come to grief. And there was another case recently which also was argued to involve the evasion of tax, called Con and Wagshaw, and the Court of Appeal in fact found on the facts that it didn't, but for good measure what they did was that they sent the papers to the Inland Revenue. So the parties had a risk of their comeuppance there, and I'm virtually finished. Where the Archbishop of Canterbury was wrong, if that's what he meant, and he hasn't quite said, and nobody really knows, was to evoke the spectre of some sort of parallel system of law interposing itself into areas of personal life, which would offend most people's notions, although one has to be terribly careful here about being prejudiced about other systems of law, and particularly the way it's practiced in some rather less advanced countries, Muslim countries, where we're very concerned about it, such as what we've seen